like you guys stated, I'll just take that particular note forward. So when I'm talking about alternative dispute resolution, so this is not only about this subject. No matter any of the corporate subject or any of these kind of subjects which are very vulnerable in nature. So if you touch those subjects, the first thing which I always tell the students is that you need to understand the meaning. If you get the concept correct, it is very easy for you to frame your answer. Okay, so here when I'm saying alternative dispute resolution, that means we are talking about something which is alternative to the existing or pre-existing method. And what is the pre-existing method which we are talking about? Dispute resolution. And when we talk about dispute resolution, so what we generally do, so you might have heard very commonly used anything of any drama or any kind of fight which happens between people, anything of that sort. The very basic thing which people say, तुमको कोर्ट में देख लेंगे. Okay, this is the very basic thing which comes to the people mind. So basically what I'm trying to say over here is that we are talking about something which is alternative to the traditional method, which is rightly pointed out by the girls as well. And that traditional method is litigation. That means we are talking about something that we are not going to the court, but if we have any kind of dispute, we are going to settle it out of the court. And that is the entire meaning of alternative dispute resolution. Am I clear? I think this particular thing is clear. Yes or no? Can I have some yes or no? Okay. Now moving ahead, when I say this particular thing, alternative dispute resolution becomes very fascinating for the students. They feel that, okay, fine, it's a very new term which we are listening today. It's a very new thing which we are studying today. No. Basically, if I talk about alternative dispute resolution, it is not a new term. Maybe with a layman perspective, we can consider is an in a day-to-day life as going away from the traditional method, and we call it as external dispute resolution system. But this is not the situation. Here we are talking about that there is a third person, okay, and this third person is listening to both the parties. And when this third person is listening to both the parties, he is trying to form a conclusion. This what particularly arbitration is all about. Now, when I'm talking about this concept where there are two parties in dispute or two parties in conflict, and there is a third person who is actually listening to both the parties and trying to understand what is the query and what is the situation there, and tries to give out a solution to it. This is something which we are following from a long back tradition. This is not a new thing. In every lecture, whenever I have to state anything about arbitration or anything about mediation conciliation, I always mention one of the examples, and that is of King Solomon. Okay, if you date back and if you go back to that particular time, even in his jurisdiction, there was a matter which came across. There was a small child who was crying, and there were two persons who was claiming that I am the mother of this child. So he has to hear the things both the ways, and he has to analyze the sentiments and emotions of the child, and he had to figure out that who is going to be the right, who is the right owner, or not owner, I won't say owner will be the right word, but who is the mother, who is the parent, who is the actual guardian, whom should the child should go to. Okay, what is this? This is a kind of arbitration which is happening, which was long back. Okay, cut to if you talk about our grand norm. Okay, if you think what Kelsen gave in Juris put as the grand norm, the constitution, if you talk about our constitution, I think you all might be very much aware of the concept of panchayat, which has also been recognized in our Constitution of India. Yes or no?
Yes, ma'am.
Okay, I think panchayats is the same thing, where you're sitting under the tree. You have the whole panchayat system. You have the panch who is listening to every matter, everything, and trying to figure out that, okay, if this is the query, if this is the problem, what is going to be my approach? What is the solution of this particular problem? So that is something is being recognized in the constitution as well. If we date back a little, okay, and why am I giving you this historical perspective? Because the moment I say ADR, everything which comes to everyone's mind is, okay, we are talking about alternative dispute resolution, it's arbitration, mediation, conciliation, negotiation. Today's time it's MIDA process, online dispute resolution, it's blockchain technologies, fast track arbitration. All these things, come to our mind. Of course, we'll be touching everything. Okay, it's a part of alternative dispute resolution. But there is one subject which every law student think that why are we even studying this? Even I, during my 4 years, even I used to think that this is so dry in nature. Why am I even studying this? Okay, and that particular thing is basically your alternative dispute resolutions jurisprudential analysis. So jurisprudence is one of the subject which everyone thinks about it, but it is very important for us to know the history. It is very important for us to know the crux that where do we stand. Okay. So here also I am trying to giving you a nexus, and what we are seeing today is basically a very new, I would say, chapter of the old book cover. So what we are studying today as ADR, it's very fascinating to us. It's something which is not very new. Okay, this is something very old concept which we have been following from a very long period of time. And today what we are trying to do is just trying to join the dots which we already have so that we can use it in a much more legal and a perspective. That's all what we are trying to do. So I can give you plenty of examples for that. Like for instance, I can date back ancient India. Ancient India, the most famous Indus Valley civilization, Harappa and Mohenjo-daro. Okay, even they used to follow these particular system of ADR, alternative dispute resolution, during our ancient India times. If you will come to our Vedic times, our literature, okay, our Vedic era, all the Upanishads and whatever treaties and Vedas we used to follow at that point of time, even they used to have certain primary bodies which basically performed the task of an arbitrator, and the whole process was known as arbitration. Although they had specific names at that point of time, the local courts where the people used to go, they were known as pugas, Pugas. Various tradesmen used to approach a certain professional set of layout. Those people were known as serni. Okay, and the ones those who used to resolve the family disputes and the family ties, they were known as the pulas. Okay, so even at that point of time, the Vedic time, all those places, we used to have this kind of alternative dispute resolution system. Then, speaking about, in a more historical format, if we are talking about the histories, we just cannot miss our dynasties. Okay, we were having Mauryan dynasty, we were having Gupta dynasty, we were having the Mughals. Each and every dynasty with the name of some other particular aspect, they always used to follow these kind of ADR system. Like for example, if I take up just in case Gupta dynasty, okay, their administration division was known as Rajya, Rashtra, and Disha. Okay, again, there were numerous powers which were being divided among these kind of town halls and villagers, and you can call it as a judicial setup, and they used to hear the dispute of the people and resolve it. If we are talking about the dynasties, we have to take the reforms of the Mughals. Mughals also in the Arabic time, in the Islamic texts, they used to follow arbitration. And in their term, arbitration was known as taqid. Okay. Whereas the arbitrators going to come across today, you'll be studying about the latest amendment which has happened right from the 1996 till today. Okay, you'll be studying each and everything. But the point over here is that when we are starting from somewhere, there is also below that. It's just like an iceberg, I would say. Okay. So if just starting the above part, it is very important for us to know what was below, how we actually started, how this particular concept actually started. Okay. Now, these were the time where the ancient rulers or the ancient civilizations used to talk more about arbitration, or I would say the concept of resolution of the dispute with the help of third party. Okay. Then came the British Empire or the British rules. Even they recognized the mechanism of ADR. Okay, Eastern India Company at that point of time, the British Raj, even they, actually adapted this particular concept, and their most important point of adapting the concept of alternative dispute resolution was trade. I think you all might be very much aware of the fact that they actually entered into our civilization because of the trade. And when you are doing trades, okay, when you are talking to people, when you are trying to set up a business, okay, so at that point of time, conflicts do happen. You just cannot have a watertight container and say that okay, these are the set of rules and regulations, this is what I have defined, and whatever business which we are doing, हमारे बीच में जो भी प्रॉब्लम्स होंगे, जो भी डिस्प्यूट्स होंगे, वो सिर्फ इसी तरीके से हो सकते हैं. नो, यू कैनॉट डिफाइन दैट, यू कैनॉट स्टिक इट इनटू अ watertight container. Okay, same happens with the company law, same happened with the corporate law. You just cannot put things in a watertight container, so you have to be very flexible in nature. So even these people, they never wanted to go to those royal courts and everything. They thought that okay, fine, we are doing a different kind of business. We are into trading activities. So anything of any kind of dispute which occurs, let's try and get it resolved amicably. Okay. So they also gave a very good context, I would say a very, a legal language to this particular concept. And they had those Bengal regulations, okay, Bengal regulations, the Bengal resolutions of 1773. They also formed these particular situations with respect to arbitration, and they also forced that if you have any issues, why don't you take your matter to arbitration? Okay, and they were the one who actually started that if there is something called arbitration, there has to be a binding effect. Okay, so there is going to be a binding effect on the parties. So I would say that we were having the concept from a very long period of time. The Britishers, the British civilization actually laid the foundation, or I would say a legal stone for arbitration, mediation, conciliation. And today, what we are seeing, today, what we are following, whether it's Arbitration and Conciliation Act, whether it's the Mediation Act, whatever we are following today, is something which was very old, but now we have a proper structure and culture to it. So we basically know that if this is the thing, this is the process we need to approach. So basically, we have actually defined very old concept and we have given a very new culture to it. Okay, so they had all those, Madras Regulation Act. They had different protocols and everything, which was actually being taken forward in the post-independence, and I would say that could be the origin of legislation for arbitration in India as well. Okay, and of course, there were numerous case laws and everything which was been coming at that point of time. There was very famous judgments which were being where even the courts recognized the concept of Indian arbitration, and they also mentioned that you should not make it unnecessarily very complex. Okay, there's a very famous case of Dinakari, that the judgment I'm mentioning about is from 1930. Actually, this case is of 1930. They also mentioned that yes, of course, arbitration is very important, but the Indian Arbitration Act is unnecessarily complex, and the legislature should try and bring certain reforms. So what I'm trying to say is that according to their societal needs, they have tried to make certain things to encompass certain things in arbitration. But yes, of course, that is with respect to their society. Now, the moment we started developing, we started coming into our post-independent time period. Okay, so there were a lot of pitfalls and disagreements which took place. We had Arbitration Act of 1940. We have Arbitration Protocol and Convention Act of 1937. We had Foreign Arbitral Awards Act of 1961. All these were being ruling at that point of time. Even civil procedure courts started recognizing the concept of alternative dispute resolution. So all these things had a pitfall. Why it had a pitfall? Because there's again a very famous case of Guru Nanak Foundation versus Ratan Singh. You can easily go and check that particular case. I believe it's a case of 1981. There was something which was being quoted by Justice Desai. Okay, when he was saying that there are so many people who actually want to go opt for arbitration, but the issue which is coming there is that the people are not able to understand the legislation. The people are not able to portray how the things is. So he gave a very famous line. He stated that the way in which the proceedings under the act are conducted without any expectation has made the courts into a very challenging form, and this has actually made the lawyers weep and the legal philosophers laugh. Okay, so these were his kind of words. So the ones, those who have actually introduced this concept, they're actually weeping and thinking that what has been done, the lawyers are not able to execute it properly. So the whole idea is that if you want people to opt for arbitration, if you want people to opt for alternative dispute resolution, make sure that your legislation is also very easy so that people can actually understand about it. Okay. So the post-independent period, we had the ancestral model law, the United Nations Commission on International Trade Law. From there, we actually adapted various concepts inclusive of international commercial arbitration. And today, what we see is the Arbitration Conciliation Act of 1996. And this is the post-independent period. Obviously, in the modern era, we have seen a lot of different area concepts which are being coming into picture. We have also seen the various, I would say, the amendments which has taken place, 2019 amendment, and all those different amendments which has taken place. So what I'm trying to say over here is that ADR, what we are listening today, okay, the non-adversarial process, which is actually based on the cooperation between the parties to ensure a fair and I would say a just and a procedural situations for the citizens so that they can get the justice is not new to us. It is a very old concept which today what we are adapting is into a more structurized format. I think I tell me whether this historical nexus of ADR was clear to you or not. If yes, then we'll move ahead further with the different types of ADR. Please let me know. And just in case if you have any queries or questions, you can even post that to me so far. And if you want me to proceed further, you can just let me know about it as well. Is it clear so far? Yes or no? Okay, understood. So we'll quickly move ahead forward because we don't have much of time as well. So I'll just go ahead with the concepts of the ADR mechanism. I'll just try and cover the concepts of ADR mechanism. Now, before going into the concepts of ADR mechanism, I just have a very plain and a very simple question to put across. You can give your own views. Why do you think that we actually need to have this concept of alternative dispute resolution today? I know that this is not a very right time to ask this question because we have already discussed the historical aspect and we have reached to a certain nexus where we are actually going to talk about more about its developing concern and we'll also address the loopholes. But just a situational analysis, just let me know your views that why do you think that this is actually very important at the first place? Anyone? Any one of you can volunteer and just let me know, or even you can use the chat box. Why do you think that we need to have an understanding of ADR? Why do you think that we need to study something called alternative dispute resolution? Why are we even developing in this field so much?
Good evening, ma'am.
Yes, yes.
According to my view of point, I think already the judicial process of court, if you look towards, is very complicated, and people are already not educated about how they can, go approach court and how they can go for the judicial process whenever their right are got infringed or violated. Solutions. ADR kind of a mechanism not only help people to solve their matter in a simpler way, it also educate people and create legal awareness among the people that that getting justice is not such a complicated, it's not such a kind of a taboo which is being created in society, that cannot be served in quicker, easier, or in an efficient way. So I think it's important for people, especially in country like India, where every single day there are lots of disputes occurring, which does not require such a high technical or mechanical expertise. They can be solved in such a simpler manner also. So I think it was very important in country like India to have a mechanism like ATR.
Okay. Great. Anyone else? Because I have seen a lot of chat box which are being popping, and I have seen that there are people who are having their views. But anyone else who wants to volunteer and share any other views? Anyone else? Okay. If I'll go to the chat box, so I can see that the lengthy and the time, okay, the time factor, it's time consuming. Okay, good. And very well said, Toshiba. Of course, I totally agree to what you have certainly stated. But my another follow-up question to is that before we go into the different types of ADR, do you think that the way we have created alternative dispute resolution is actually being used in the same form as it was being thought about? Anyone?
Actually, no. It's sometimes misused right now. We can say who have money, the judgment in ADR will be sometimes favorable of them, and they make other parties to compromise instead of making complete justice. I believe half justice is never been a form of justice, and half justice is not a justice at all.
Okay, great, very good, very well said. Along with that, anyone else who is having any other kind of view that, of course, he gave one side of the coin that yes, of course, it is not being used exactly the way it should have been used, but at the same point of time, my direct question to you is that what we thought that okay, fine, we'll reduce the burden of the court and the people should opt for arbitration, the people should go for mediation. Do you really think that the way we are spending so much of time and effort with this particular concept, especially if we talk about the Indian scenario. Let's not go out because, of course, at if you do a comparative study, things are at a very, I would say, a brighter side. But if we are speaking about in the Indian perspective, do you think or do you have any other views with respect to its execution? Like already I got one answer, but any other views to it?
Ma'am, I believe other than the point raised earlier, uh, these ADR cases are also being ledged onto appeals. So then the whole aspect of lessening the
Because they're
burden of the
also
courts,
yes.
it's again coming back to the courts, and thus it is thus increasing the number of cases instead. So I think the initial concept of ADR is now also not being executed the way it should have been.
Okay, great, great. So I have got two sides of the coin, and I'm going to discuss what it is being just stated. Also, why am I asking you these questions in the mid of the evening when we are having this kind of workshop? Because obviously, first is the approach when it comes to virtual lectures. Things are very difficult. Things are very different. I don't know out of 51 people, excluding me, how many of you are actually trying to connect what I'm saying. So of course, that is a difficult task. And secondly, whenever we are into a session, whenever we are into a webinar, whenever we are organizing any kind of event, I have a point that no matter you touch a very small topic and discuss, don't uh, cover the entire portion, but at least try and take out some solution to the discussion which we are doing. Okay, so now if I have given you the historical perspective of ADR, and now when I'm saying that we have developed so much and we are still developing in this particular field, do you really feel that that particular development is getting executed properly the way it should? So no, of course, the answer which came across is no. Absolutely correct. Because I also want to add on one more thing to it. Misuse, yes, of course. Execution issue, yes, of course. There is one more thing which is lacking at a very large scale. Okay. So when we speak about ADR, alternative dispute resolution, there was a very famous case of Booz Allen. Okay. So if you search the case of Booz Allen, it says that what are the subject matters which should go for alternative dispute resolution and the subject matter which should not go for alternative dispute resolution. So initially they used to say the matters which are very serious in nature, which also included your insolvency and bankruptcy matter. But today, if you will see, your IBC matters are actually going to arbitration. But they also say that the offenses, the criminal matters should not go for ADR, the ones those who are of having serious offenses. But yes, of course, in order to reduce the burden of the court, it is very important that the corporate dispute, the corporate conflict, okay, the employer-employer dispute, they should go for ADR. But according to the empirical research which I did for my thesis, for my analysis, okay, it is a very sad part that most of the people, firstly, are not aware of this process, alternative dispute resolution. I don't know how many of you all will agree to me on this particular part, are not aware of this particular process, because obviously it is private, voluntarily, non-adversarial process. And secondly, even if they are aware, they don't have a trust to this particular process. I will not take names, but there are huge companies which can easily go and resolve their dispute through ADR, but they are still opting for litigation. Do you really think that there is a specific reason behind it, or do you have a solution to this particular thing? Because see, I am going to give you the development point of view. I can tell you there is mediation. I'll give you mediation act. Kya hota? I'll explain you that. I'll tell you negotiation. I'll explain you. I'll discuss what is negotiation. We take up a lot of mediation competition. I can even go far and I'll tell you that how you can become a mediator. What are the skill sets you need to follow? But the problem which I want to address over here is that even after going ahead with so much of development, even after going ahead with so much of awareness, there are still people, there are still companies who are not opting for this particular mechanism. Do you think that there is a reason behind it, specific reason? If yes, do you have any solution for it? Anyone?
People are not want to compromise with the half justice is the first of the reason. I already said it. And first I will say the same reason. And second thing is they don't want to believe ADR because they already said half of there is only whose is higher party they support them. And third thing, to avoid this all, we can do a simple things like adding a judge mandatory in the mediation and making the procedure a little this is now liberal. We make it a little um, more procedure to it, and maybe we may give fines or any punishment if there is any wrongs or any fraud has been happened in giving judgment of ADR, would reduce the burden of injustice.
Okay, great, great. Rightly pointed out. Anyone else who wants to add on any point to it?
Ma'am, I also think that there is a mindset in the minds of the people that court is the final thing. Like if anything is ordered or judged, if anything is said by a court, then no one can touch it, change it, or modify it once it is said. So due to this mindset, I think ATR is working as an intermediary for people. It is not the final end of the justice. And due to this mindset, people are thinking that we don't want any kind of loophole to be left out or any matter that is not get resolved. Where in the future we don't want to face any other kind of a problem, because once we get the order of a court, we are finalized that okay, we won the case or our matter got resolved. So due to this particular mindset, also people are not that much getting involved in this kind of mechanism and rather going for the court.
Understood, understood. So very rightly pointed out. And there is one more aspect which I would like to, add on to this. That yes, of course, they feel that court is the final authority. One thing which we are trying to address right from the Arbitration Act of 1940, and we are still doing it. The Law Commission reports and everything is still doing it, even after your 2019 amendment and everything. That is your judicial intervention. And like already it has been pointed out by one of your fellow mate that people feel that even after going through the arbitral award, we still have to go to the court for appeals and everything. So that is that kind of scenario is already happening. That kind of scenario is still persisting. So why should we actually go for this particular alternative dispute resolution? Let's directly go to the court. Very rightly pointed out. Okay, so the solution to this particular problem is that a you need to minimize the judicial people trust the system. That is the first point. And the second and the most important thing is that when you are reducing the judicial intervention, make sure that you're making the whole process independent of its own. That means they don't have to go. Like for instance, if you take any of the international commercial arbitration or you take arbitration institutions, they don't actually rely upon the court settlement process. They feel that okay, if anything is coming to ADR, right from the nook to corner, everything has to be resolved by alternative dispute resolution. They don't go for any other particular, I would say, the situation or situational analysis. They don't want to go to any other place where they can resolve their dispute. For them, this is fine. Okay, so what we need to work on is first is awareness, and second, to make this particular process independent of everything. That right from the appointment of arbitrator till section 34, setting aside of arbitral award, anything whatever is happening has to be done under this particular process. Okay, which is going to take me to the next point, that is your different types of ADR. Okay, so of course there are various types of ADR as well. We have arbitration, we have mediation, we have negotiation, we have conciliation, we have lok adalats, we have no document arbitration, we have blockchain technology, we have ODR, we have mid-art process, we have fast track arbitration. Okay, so what I'm trying to say over here is that we are developing in every stage. That is not the point over here. We are developing, we are going forward everywhere. But the situation over here is that the people need to understand. Okay, the people need to understand the importance. Arbitration, you have a particular third person who is known as the arbitrator listening to both the parties, giving a certain award which is known as the arbitral award. Mediation, today we have the Mediation Act of 2023, which is actually acting. The mediator becomes the the felicitator between both the parties, try to take out a common solution. Okay, unlike the arbitrator. If you talk about negotiation, something which is used in the international perspective every day, where even the nations negotiate. Okay, conciliation, again you have a third party who is the conciliator, and it is recognized under the Arbitration and Conciliation Act. Lok adalats are known as the people court. If there are any matter which is at a pre-litigation stage, we definitely take it to the lok adalats. Then we also have the mid-hour process. Okay, mid-hour process is something which can be used interchangeably. So this process basically developed why? Because people used to opt for arbitration and people used to opt for mediation. Okay, and if the matter doesn't get resolved by arbitration, they wanted to switch to mediation. And if it doesn't get resolved by mediation, vice versa. So what happened? This particular process of mid-hour was being developed, where you can just have one person who can act as a mediator also and as an arbitrator also. So you try and save money. ODR is something which got its sake and development during the COVID times. Okay, alternative dispute resolution. Then you also have blockchain technology where you're dealing with the smart contracts. Sadly, we don't have any kind of legislative provision. We still have to rely to the unsettled model law to take things forward. But at the same point of time, blockchain technology is something which is, which we are working in our day-to-day life. Again, we have no document arbitration. Okay, no document arbitration is something which where we say that if you want to fast track any kind of process, there we use no document arbitration, and it has actually been recognized by the 2015 amendment. That of course, if the party says that okay, we don't want any kind of oral, different kind of documentations which are being going across. So yes, of course, the arbitrator or the third party who is facilitating our dispute can just see the documents and then come to a certain conclusion. So that is also one part of it. Then we also have fast track arbitration, because that has been rightly pointed out by one of your fellow mate, that these days what is happening, the party who are at the higher range, okay, the party who who are well paid off and everything, so they try to hijack the entire process. They try to take over the entire process. So therefore, it becomes expensive. The main motto why we have ADR, to save time, to save money. So that is actually going into a loss, and therefore we have introduced this kind of fast track arbitration where we have set the time limit. That this is the time limit, and this is where you have to resolve it. So what I'm trying to say over here is, in my concluding remarks, I just wanted to point it out that undoubtedly we had climbed a long ladder. If you will see the Indian perspective, undoubtedly we have climbed a long ladder. But looking at the current situation, looking at the current scenario, there are still certain things where we lack. Okay, the first part could be with respect to your awareness. The second part with respect to trusting the particular aspect. Of course, when I'm talking about trust, we see that a lot of divorce matters these days go for mediation. Okay, so the courts are supporting ADR. The CPC says so. Even speaking about different examples, if you will talk about industrial dispute, even they opt for alternative dispute resolution. If you see Indian Contract Act today, every time if you have a dispute clause, it says that any of the dispute which occurs between the parties need to be resolved through alternative dispute resolution before going into the court. Of course, it is a conscious call. Both the parties need to agree on that particular aspect. But we are trying to push this system because we have climbed so much. We have tried to frame it out so well. So we are trying to develop this process. But yes, of course, every particular process has a certain loophole. And this is where we need to develop. So yes, of course, we do have climbed the long ladder and there is still a lot of huge things which we need to achieve. If we speak about the international commercial arbitration aspect, if we speak about the institutional arbitration, so there are certain long things which we still need to do and we still need to cover and we need to process it properly. So, with this, I just want to stop here for the day because I feel that I have given a particular historical background. I've tried to discuss the different types of ADR. I have given a little hinge on international commercial arbitration, and I don't want to burden the students with too much of information. So, you can just have a small analysis on whatever we discussed today. If you have any kind of doubts which you want to address right now, you can definitely use the chat box. You can ask me directly. If no, you can approach me later also on the LinkedIn profile. So with this, I would like to hand over to the organizers. Yes.
Thank you, ma'am. Thank you, ma'am, for taking the time to share your valuable insights with us. Your expertise was truly enlightening. Thank you for breaking down the complex concepts into easily understandable parts. We are grateful for your patience and willingness to answer the questions. Your session has definitely enhanced the understanding of the subject. Thank you so much, ma'am.
Thank you. Thank you so much.
Um, Ma'am, do you think
Yes.
we can make ADR loopless? What measures you will recommend to make it loopless, and or we should stick with the regular procedures like court?
No, definitely. You should definitely opt for C. Uh, Very nicely pointed out. Very good. Just think about something. If we are actually developing something, okay, if we are actually having a new development, if we are developing a new process, why not to make it that easy that people can actually opt for it and people should actually understand and go for it. Okay, so we should definitely analyze the process and see that where are we lacking. We just mentioned, a bit of the loopholes. There are way lot to it when you speak about the execution, when you speak about the foreign awards, when you speak about the public policy, when you speak about Section 34. There are a lot more things to discuss. Into a very flexible form, we can remove the loopholes and we can actually ask the people into a very short period of time and into a very amicable way. So definitely we can work upon that.
Then, what measures will you recommend to make it loopless, ma'am?
See, the first thing which I rightly pointed out is awareness. Okay, that is the first point. Now the question comes, how awareness? Okay, so I'm definitely going to answer that, and I'm not going to take too many points so that it becomes really difficult. The first one is awareness, and the second one, which I have also mentioned during my research, is discussion. This sounds very simple. Okay, awareness and discussion. Why are we even talking about awareness and discussion? Awareness, A, there is such a process which is existing in India or it is persisting in India. If you opt for this particular thing, your dispute's going to get resolved very easily. Okay, so all the educational platforms, like for instance, I work for different organizations. I work for different, educational organizations, whether it's Bharti Vidyapeeth, whether it's Symbiosis, or even, taking up online lectures for different colleges and organizations. Uh, Everywhere we have something which is related to ADR. I try to set up something related to ADR. Like for instance, I have a Madhyasthata cell, which basically deals with all the matters. I keep on doing webinars with respect to ADR. I keep on having conferences. I keep on sending students, train them for mediation competition, try and give them the understanding of what ADR is. So what I'm trying to do, I'm just doing, I would say, 0.5% of awareness from my end. institutions can actually introduce. If we take it to a higher spectrum, okay, when I'm talking about discussions, so generally what happens, we make laws, we execute it, and then when there is an execution failure, we try to bring back the law. This should not happen. The people, the legislatures who are actually making those kind of laws should have a proper discussion for, they should actually opt for those people for whom they are actually making those kind of rules and regulations. They should actually have a proper discussion and need to understand that what are their needs. In accordance to their needs, they should actually frame the different laws and legislation. I think these are very baby steps which I'm talking about, but if we do it at a very large scale, I think there's going to be a great change with respect to the loopholes and exclusion.
Thank you, ma'am. And I have another question. Is it good to development of advocates? Developing ADR can make advocate work less, or how can a advocate can monetize good by recommending ADR to their clients?
See, one is with respect to the work which you are doing, the aiding facility. The second one is with respect to your finances. So you cannot mix both the things. Okay, that is something which everyone should understand. Of course, when you are into this particular profession, everyone thinks that of course this is the way how we can make money. Okay, so that is a different angle to it. But at the same point of time, you should definitely recommend your clients that you need to go for ADR, you need to resolve your dispute through alternative dispute resolution. Someone over here stated that even half justice is not good, right? So the same thing happens over there. So if a client is coming to you and saying that I'm in so much of problem and so much of trouble, and you are saying that okay, fine, let's go and file a case and we'll see what will happen. You in your heart are also very much aware that this person is already into trouble, and I can try and resolve this dispute through ADR mechanism as well. Okay, so let's try and see that how things work out. So if you're going to give that particular client at least 70% of satisfaction, your monetary benefits are easily going to come back to you, because that person is going to tell 10 different people that yes, of course, I have got the justice with this person. So you should not actually think in a very small spectrum. You should take this particular thing at a very larger spectrum, because I would say the legal profession is the most noble profession in the world. So we should, think in that particular way. Yes. Any more question? Okay. If there is any more question, you can address me to the chat box, or you can actually address me later through my LinkedIn profile as well. And if everything is fine, we can stop here for the day. The organizers.
Yes, ma'am. I think no one else has any doubt, so we can.
Okay. Okay. Thank you so much.
Thank you so much, ma'am.
Thank you.